And if you mention one review application.
Give it. After the next week. After next week.
May I have the kind leave to move this application unlisted Millet? Millet, the fact says, Millet, move this application Millet, unlisted Millet. There are compelling circumstances and urgency Millet. Millet, the petitioner are applicants to pharmacist grade 3 recruitment process conducted by the West Bengal Health Recruitment Board. Now, Millet, according to the advertisement, an applicant has to be a registered pharmacist under the West Bengal Pharmacy Council. Now, my lord, the applicants applied to this advertisement. The CBT, the computer-based test, is going to take place on January 14th.
So what is the?
Well, we have been rejected. Our applications has been rejected
For?
on the ground that we do not possess the renewal certificate as on the last date of submission of the application. My lord, the advertisement did not have any.
For the other side.
Millet, I'll ascertain that Millet, who regularly appears for the state of West Bengal.
It is arising out of a writ court order.
No, Millet, since Millet, West Bengal Health Recruitment Board, it lies before the SAT.
Filed before the SAT.
Yeah, Millet, we filed before the SAT. Millet knows Millet. SAT is not functioning, Millet. Yesterday, Millet.
Find out who is appearing.
Millet, I shall, Millet. Grants me leave, Millet. I shall ascertain who appears. I'll stop. It, Millet, when it shall appear, Millet.
You intimate, then tell us before rising.
At 1:15.
Yes. You come back at that time.
Item number 1.
We are informed that
Call the next. Item number 2.
Item number 2, I am late by Mr. HON'BLE. I am praying for a short passover.
Sorry, you start, we'll come.
The petitioner is a employee, a government employee.
What is the date of his retirement?
His date of retirement is 29th of August 2025.
August
August 29, 2025.
25. He was working in the state government
He was working with the state government
as
a revenue officer.
revenue officer.
Habibpur branch lordship.
What is the date of charge memo?
Charge sheet was filed on 30th January 2024. Prior to that, there was a show cause notice.
30th January.
30th January
Yes.
2024, lordship.
So the proceeding was in progress at the time of his retirement.
That all financial benefits will be not production rather than.
No, he wants squashing of the charge memo. How that can be, we will decide. Don't worry. Yes.
My contention is that Lordship, Rule 10 specifically states that. May I just place the facts in short?
Sir, hardly relevant, sir. This is what is your prayer in the OA? Let us see.
Praise
Yeah.
What is this practice? We don't know. Why do you do this? So irritating to the court. Why can't you file a complete writ petition? You will file it in piecemeal, then file supplementary. What is the fun? What do you gain by doing so? We don't know. Just increasing the volume of the brief for nothing. Every day we are saying, we are refraining from imposing cost. But you are not, it is hardly making any impact on the. Why do you file like this? Give it. Where is it? As it is, you don't file paper book. You file it just like this. Although the rule requires filing of a paper book. And then you increase the confusion by filing small petitions and applications just to complete the records. And then it becomes a difficult task for us. You will just argue and walk away. Obviously, you are not obliged to do anything more. And then we have to grapple with this disorganized brief. We don't know whether you give it to us to understand or to confuse us. Give us, where is the application?
Kindly pardons me, I have only one copy.
Very nice. So one of us will hear. Everything should be as per your convenience.
She may just come back.
Very unfortunate, sir.
Just come back with the complete brief.
Why? Why? We want to know why. What did you think of? You pay cost. Where is your senior? Let him come.
Kindly grants me short.
This is not to be encouraged at all, sir. What Passover? Everything for your convenience. Everything. First short Passover, then supplementary, then one copy, then if not possible, then Passover. Yes, you proceed with your submissions. We don't need the way. You proceed. If you don't want to show it, we'll record that without placing the way you have proceeded. You proceed, please.
In this matter,
See, at one point of time, you were also young at the bar. Every page I used to check from my senior chamber, whether it is an order or not, before filing the brief. That is why we, at least speaking for myself, I get it. We try to maintain the highest standard. Still, we may commit errors. We are all humans, but this is not an error. This is a. I don't know. I don't want to say. Yes, please proceed.
kindly pardons me for my.
What is it? What is it? What fact you are trying to show? Show us.
The petitioner was posted as the revenue officer on the BLRO Habibpur block at Malda. Subsequently, he on 30th of August 2022, the petitioner received a show cause notice.
No, 30th January 24, you said.
The memo of charge sheet.
Yes.
So before that, 30th August, show cause notice.
There is a show cause prior to charge memo.
Charge memo.
So that is a pre-charge memo stage. So that is over. Now that is over. So now there is a charge memo.
The charge sheet filed The charges are, Lordship, the
It's not a
it is
charge sheet, it is a charge memo. Yes,
charge memo is annexed at page 24, Lordship.
page.
Page 24 of your Lordship's brief. May I just read the articles of charge? Sri such and such revenue officer Malda, while discharging his official duties and responsibilities as erstwhile revenue officer with the block land and land reforms officer Habibpur Malda, conspiringly expunged several LR record of rights or khotians as elucidated below. Record of rights appearing to Mouza Bulbul Chondi, jail number 212 under jurisdiction of Habibpur Development Block, being number such and such, respectively, which have been deleted by initiating individual miscellaneous cases number, MC case number such and such, generated through his personal e-Bhuchitro ID on 13/7/2022. No comprehensible application from any individual or any preceding permission from the competent authority had been contemplated prior to expunging the finally published record of rights. A substantial complaint was lodged flouting the deletions, on basis of which a probe was conducted by the Deputy DL and LRO Malda and report furnished. The BL LRO Habibpur could not extract any miscase record or proceeding related to the miscellaneous case during the meticulous probe conducted by the Deputy DLRO. In fact, all the miscases generated by the incumbent were suo motu. The record of rights appertaining to Mouza Binodpur jail number 44 under the jurisdiction of Habibpur Development Block, being number such and such, respectively, which have been deleted by initiating individual miscellaneous cases number MC such and such, generated through his personal e-Bhuchitro ID on 24/6/2022. No comprehensible application from any individual or any preceding permission from the competent authority had been contemplated prior to expunging the finality published in the record of rights. The incident of these deletions was detected while probing into the previous matters as explicated in A above. The BLRO Habibpur could not extract any miscellaneous case record or proceeding related to miscellaneous cases during the meticulous probe conducted by the Deputy DLRO Malda. In fact, all the miscases generated by incumbent were suo motu. Then, Lordship, it states that this is completely in contravention to the memorandum number such and such, of which says that in some cases corrections of record of rights are made without drawing proper proceeding. Such case of tampering of records is a cognizable offense under Information Technology Act, and the offender is liable to be arrested on a FIR lodged against him. Since record of rights are legal documents, any complaint or tampering of record of rights should be taken seriously and should be inquired by a senior officer, and the offender should be proceeded against under IT Act 2000 or be suspended and proceeded through disciplinary proceeding. Such conduct on the part of Sri such and such is tantamount to dereliction in duty, misutilization of government position with purposive and malicious intention. It is thus clear that such action on the part of Sri Pavitra Kumar Poddar is unbecoming of a government servant, which attracts the provision of Rule 31, 32, 33 of the West Bengal Duties, Rights and Obligations of the Government Employees Rules and Section 65 and 66 of the Information Technology Act. In Lordship, the second articles of charge states that Sri Pavitra Kumar Poddar, Revenue Officer, was asked to show cause on 30/8/2022 by the ADM and DLRO Malda, while memo number such and such, for illegal deletion of only 3 record of rights, to which the incumbent sought his innocence and proclaimed himself innocent on the ground of being E. Bhuchitro illiterate through his reply dated 31st August 2022. However, on a preceding occasion dated 23rd August 2022, the incumbent had, through a written deposition, proclaimed himself as impeccable and innocent. He further sought clemency from the district authority. But
Yes, so what is your submission? We have gone through. Yes, you may. Why you file a writ petition like this, sir? Why OA is not part of the writ petition? No. You please proceed. We don't encourage this at all. Yes, you proceed. What is wrong with the charge, ma'am?
Proceeding after retirement, after cessation of the employment relationship is permissible only in cases where allegation is that there is a defalcation between financial loss of the government. If there is no financial loss of the government, in that case, cannot be permitted. There is some judgment of
Judgment will come after the provision. Yes.
my point is, after my retirement, they cannot continue with the proceeding.
So let us see the provision. It's a very small, simple issue. You are referring to DCRB. So there is a bar to continuance of such proceeding if it does not involve financial implication. Let him complete. Don't worry. This one. There is one like this there also.
Take one, under the right of history of pension or part of it, whether permanent the right of following where part of the government. If the pension is found in a or negative, during the period of service provided that the particular proceeding final was in service. Then after the final return officer became continue the conflict with the authority. I think it was founded. This particular as the officer the proceeding is not restricted by the officer of the service. The report is required but during
So your stress is on such proceeding. Your stress is on such proceeding. Yes. Obviously, because one says pecuniary loss, A says such proceeding. So you say only if it is such a proceeding, then it can continue. Now let us see the judgment.
This, the government reserves to withhold the pension permanently or already covering if pensioner is found guilty during the period of injury such as after such a departmental proceeding is instituted by officer. So such he is saying only for recovery.
Urgent order very.
Yes, proceeding is quashed.
Yes.
It has been relied on the 1990.
Not required, it is considered.
2006, Supreme Court
Yes.
2006-7 Supreme Court
That is also referred.
also developed.
Not required.
I did not refer to the subsequent judgment of the Supreme Court. That is why I said that the previous judgment of the Supreme Court that has been considered in 2015 judgment.
No, that after you complete, then we'll hear.
So submission will not in this case will not. Allegation is that yes, there is tampering of not the record of life, which he has denied even I don't have the technical knowledge to do. But that is under consideration report. Report has not.
That is not our concern. That is not the concern of this court. The allegation is 13 record of rights he has changed, and that also suo moto without any application, using his personal Bhuchitra ID. That is the substance of allegation against him. And these are falling in different areas, two different areas. Yes.
Okay. Content to বিদায় দিচ্ছি।
Oh, there are two appeals. Yes. Both judgments are relying on Rule 10. They are both interpreting Rule 10. Hmm? Yes.
Seven is considering the judgment of the honorable teacher, that is referring to level it was individual you have right. These are properties they have a right to recover. That is the finding. If it is not ultraviolet, then to take it ultraviolet. The government has a right.
According to you, 2006 lays down a different law.
Ultraviolet. Says that the government can recover the loss.
Yes.
That extent it is ultraviolet.
No, but does it say that it is only for this purpose that a charge memo can be issued?
That has been 2015 to that. But there are series of judgments which have been considered with everything not honorable decision.
It may have been. There is one Supreme Court judgment considered.
That judgment is not considering but all previous judgments.
Huh?
The constitutional benches are also considered.
No, but this particular rule has been considered in 2015. We are not speaking about the law in the context of another rule.
So if the law is that the government cannot recover, cannot initiate a proceeding except in case of recovery.
This is not, there is no such law. There is no such law. It will all depend on the rule. See, even in the service rules or in the retirement rules, we have come across certain rules which give a time frame within which a proceeding can be initiated even after retirement. Because in every retirement benefit rule, there is a condition that future conduct is a prerequisite for grant and continuance of pension. So you cannot escape. You cannot escape. Yes. Yes, most cases in my parent state also it was 4 years. 44 rule 44B of the Bihar pension rules. Which provision? 10B. In case of a civil proceeding. Okay. Shall not be in respect of any event which took place more than, yes, it is same pari material.
But a charge has been issued 5 years in service.
So it is not it depends on the rule. What the rule contemplates. Some rule contemplates withholding of certain dues during pendency. Some rules say are silent. Then the court says, though, if there is no provision for withholding, you pay it subject to result. So it is, there is no law that it can be done only for recovering an amount. Then why you have not come today? Your brief is incomplete. You have not come with all the judgments. When the matter was called, you were not here. So we have been asking your junior everything as per your convenience. What this? How kind? You sometime you also be kind to us. Short submission advanced by the learned. Oh, DCRB is there. DC. Don't file a writ petition like this. File it complete. We have been saying every day. Yes.
Item number 3.
You were making submission.
My lord,
Yes.
if your lordship kindly allow me after finishing his submission, my lord, only 5 minutes time, because I last August I could not, my lord, raise this point, my lord.
So you will raise a new point after he
No, my lord,
finishes.
no, my lord, when matter was admitted for hearing, my lord, issue was framed, my lord.
Where is that order?
Yes, my lord, in my paper book, my lord, page 136.
Page?
136, my lord. The order of admission dated 27/20/2005. Paragraph number 4 onwards.
Yes.
I have taken this point, point. Issue, ground number is 99.
What it is already recorded. Why do you want to show?
Yes, my lord. And another thing, my lord was asking me that with regard to admission, my lord, candidly, my lord, submit, my lord, this issue has not been specifically raised in my affidavit in opposition. Though I have stated what is his entitlement under ROPA 1998, that is postgraduate scale. He is asking for his prayer for enhancement of scale. That is
That we figured out, that we deciphered.
yes.
Although you did not make such submission, we deciphered from the record.
Uh,
You were saying 98 will not apply.
yes.
Whereas state's case is 98 applies, but he will get only the basic thing. He will
Yes.
not get by virtue of enhanced qualification
My lord.
because it is not in library science. Why do you want to repeat the same
My
thing?
lord. No,
Yes.
grateful, my lord. And my lord, overriding effect, my lord, ROPA was asking the whether ROPA 2009 had its.
Can you do this when you have
No,
completed
my
your
lord,
argument?
I missed it. My lord was asking me. I missed it. My lord. Sorry.
Now you have pointed out.
Yes.
Now what else you want?
My lord.
Yes.
My lord. Grateful, my lord.
Yes. First, we want to see the 2009 ROPA.
Division of it.
No, yes. Yes, please. Please, yes.
If your lordship kindly take the ROPA 90, I have figured everything. There is 60. But what is the ROPA 98? I memo number 25 AC, top left hand side.
Yes.
This is from 1990. This is the ROPA 98 in which I am governed. Because my initial appointment 2000.
Yes. And this was effective from 98.
98. 12 February 1999. It is called 1998 ROPA.
Oh.
And effect it has been given 1196. It is there.
1196.
Yes. 12-3. Actually 66. Answer is there. Middle portion, all teachers start from.
12.3 of the career advancement scheme. May I read for you? Page 60. All teachers, including physical education teacher and librarians of the secondary school who have improved or will improve is my case. Their qualification or who are appointed to the higher qualification, not my case. Subject relevant to their teaching and appointment. Teaching appointment is a risk. Page 25 is my entry marks. So page 25 is the requirement.
But that's not in dispute.
No, not 2007 December. Date of including the qualification, whichever is that, with effect from 1st January 1996. Just now I have told. Got it. With effect from 1st January 1996 as the case may be. From the date of appointment or will improve on this ROPA effect from 1/1/96. Prior to that 1990.
So in your case, it will be date of improving.
Yes, obviously 2007.
December 2007.
December public result. Now if your lordship kindly see the how pay fixation kindly this ROPA has been amended also to some extent. But that is page 70. He has not placed that portion. And what is the proviso clause of that amendment? Page 70. And another judge categorically considered this amendment also. And may I read for your amendment portion in of 25 in ACV 1998. Got it? Fifth line from the top. Memo number 155.
Yes.
This is the amendment of that ROPA just now I have placed. What is the amendment? Intact library. All ends now. Next page. 3. All teachers, including physical 12.3 has been amended in that fashion. Physical education teacher and librarians also include there. Of a secondary school, certain chart will include certain qualification. This portion of the mother as of 1999 law. Now, proviso clause has been amended. For whom? Provided that the higher qualified teachers, can you see there is omission of I have to read each and every word of that I have learned from this. Teacher in relevant subject or group is justified as per approved staff pattern of the school. Post of librarian is not the single cadet post in the notification itself. If the teacher is appointed through a school service commission, my appointment is from the managing committee as I told earlier. And pay will be fees as per his qualification mentioned in the school service. So therefore, by virtue of this amendment, only teachers case, why it has come? School Service Commission Act has come for appointment to those teachers in the year 1997. So government has thought it fit for the purpose of teaching post, this amendment is applicable. Not my case. My case is mother, and if your lordship kindly see the page 69. Take page 69. ROPA 98, how fixation to be made in a grade. Revision means not omission. Revision means to revise the earlier. Now, if you lordship take column number 30, librarian, page 69. Got it. Master degree holder with recognized diploma in library science. I have got in the year 2007. Initial column number 3, 14, 20, 31, 30 with a regular initial pay for master degree holder in terms of ROPA. And right hand side, column number 4, 4650 10 175 is the ROPA 90 existing and revised.
This is 98 revision.
90. That is also corresponding to ROPA 99 I shall place. He has not placed that portion. He has an omission. This is not the omission. Rate pay fixation in terms of. And column number 14. And at the time of my initial service, I was getting column number 4, graduate. Hello, got it.
Yes.
Column number 3, as per ROPA 90, column number 4, 4500 9700, as stated in the opposition also, I was getting, and but after the post graduation, I have been denied. That is my case. Now I can take ROPA 90.
So the benefit contemplated at 13 you are claiming.
As per 39, I am entitled to in terms of my enhancement of in terms of ROPA 90.
Yes.
And I am giving the entire ROPA 2009.
And 9 is applicable since?
Since notionally 1/1/2006, effect 2008 April. But I must be candid before your lordship, being officer of the court. My initial calculation to be made in terms of 1/1/2006. But although I got enhancement December 2007, actual payment of enhancement I am entitled from 1st April 2008, using 4 months or 3 months actual area. This is my duty to convey.
This will be as per 2009 rule.
9. But as on the date of introduction of ROPA, kindly take 27 February 2009.
Yes.
As on the publication, I could have got from 2007 December. Since ROPA has said so, your lordship may interpret in that manner that you are entitled from actual payment of area from 1 April
1/4/2008.
It may, subject to correction. I may lose for something last pay down, but since ROPA is there, I could have entitled from December 2007. Just I am repeating that. Now, kindly take date of effect. 1. First page. The revision of pay notionally with effect from 1st January 2006. And the pay allowances of admissible to give consequence of revision shall be actually which effect from 1st April. Now got it. Now, second page. Special pay definition 2DD. 2DD. Next page. Got it.
Yes.
Yes. 2DD2. Employee. All employee of a school, including teacher, non-teaching staff, librarian.
2DD.
2D, 2, small d, 2.
Yes.
1.
In relation to an
In
employee.
relation to an employee of scale, which employee was entitled such and such in terms of earlier. Kindly see the correspondence. Now he is saying omission. The omission cannot. Division means whether something to be modified.
In relation to an employee, the scale of pay to which the employee was entitled on 1st January.
1999. Other order and orders might have been in this regard. Now, if your lordship take annexure 4 at page 15, fixation, like 81 ROPA.
So your existing scale was that which is in the first column of the 13.
That is corresponding to 2009. Kindly see annexure 4.
of this rule of ROPA.
Existing as on 1/1/2006 in terms of detail of existing scale as mentioned of revision of pay in 2009. How it is being corresponding. Column number 10 and 11. My initial fixation column number 13 and 14 of the ROPA 98
is 10 and 11 here.
Yes.
This is corresponding to 13.
Now, next, annexure 5, 10 and 11. This is 2010 is 2009, 71 37 600. This is 39
Which page?
page 16.
Yes.
PB3, 10, column number 10.
Yes.
This is in respect of ROPA 2009, 7100 37600 3900 for bachelor. And column number 11, grade pay, same PB3, 4100, that is for master degree. Why? Answer I am giving mail. That can you take note of that?
Yes.
There is column number page 17, annexure 6, column number 10 and 11. Same. Existing pay and pay band in ROPA. Side by side. I am coming one after one, but I have learned from in that fashion, madam.
Yes.
Correct. Now, annexure 7. Just pay band 7100 of 2009. Third one box. This is my pay band of librarian. 7100, 3600, that last two, 3900, 4100. Graduate, postgraduate. Now, if you logically take last annexure, annexure 8, column number 9, and page number 90. The last annexure of ROPA 9 2009. My lord, got it, page 90.
Yes.
Now come to page 20.
Yes.
Column number 30. Librarian master degree holder with recognized diploma in library science 4650 10 175 in terms of ROPA 98. Yes, I have this.
This is the existing. This was the existing.
This is existing. And can you see 7100 3760 grade pay 410 or master degree. And library science column number 40 graduate 390. They are giving 3900 and they are in their opposition also. That is not permissible. If my lord takes the ROPA itself.
So this has been yes.
Now, if you are not, I have summarized that page 59. Since 1981 ROPA, all the librarians, and I have forfeited by honorable division. The librarians are entitled. I have given page 59 ROPA 98. Left hand side, all for the school librarian. Well, got it top.
Yes.
Right hand side is school teacher. Difference. Now ROPA 2009 I have given. That structure I have shown. Left hand side all the school librarian. Next page. ROPA 81. Omission or exclusion does not. And 1999. Well, we will find each and every figure. Now, if you look at their opposition, I am confused too. In the opposition, only point has been taken, control of expenditure has.
Yes.
And in the appeal, they have formulated the law, ROPA is not applicable. But I am also on that I was not prepared to answer before the honorable division. And that is why my lord, It's my fault. I could have prepared myself in that manner. But since the impugned order does not speak about all these things, so my lord, it is mine.
No, after going through the opposition, it became clear what is the state stand.
Opposition kindness is page 77 onwards.
Yes, all teachers, including physical education teachers.
There is actual mistake at page 78 middle portion. I am not claiming from the date of the appointment. Page 78 can you see?
No, but what has been granted to you?
I have been granted P900 gate. Here they have mentioned also in their opposition.
No, by the learned single judge, what you have been granted?
Granted for improvement qualification postgraduate skill of that is master.
From which date?
From the date of improvement, because improvement what has been used, losses on the date
So then from the date of improvement means December 2007.
I am giving the exact date, page 20. Page 20.
Yes.
Let's take the page 25, just 1 minute. Date of and last page 20.
Seven 12/2007. So therefore 7/12/2007 is pegged. That cannot shift.
That cannot see.
That is pegged. Now what will you get by virtue of this enhancement?
Energy.
On 7/12/2007, when you acquired the higher qualification, you would have got the qualification based scale as per 98 rupa. Then when 2009 came into effect, based on that, the consequence has to be worked out as per 2009. That is all.
That is all, but I am entitled to 12, 7/12. If the new rule would not have come on that date, would have come on that date, then 1st April 2008, actual year.
Therefore, we are saying you will get like everybody else gets.
Yes.
In 2009, when Rupa was introduced, taking your scale to be,
Gate pay 4100.
yes, grade pay 4100, that is the enhanced.
Enhanced for getting for the purpose of higher
Under
qualification.
2009, 4100 has to be revised like everybody else.
And that is the judgment of our High Court Honorable Division Bench head. Here, what happened? Initially, that person upon enhancement was getting. At the time of retirement, one question popped up that you are not entitled to get that enhanced rate. Therefore, you have overdone that amount. You
Recovery.
Got to pay this for recovery. Honorable Court held no. They are entitled to in terms of the ROPA 90. So therefore, there is no question of order. You make payment as per revised. Twofold enhancement is I am entitled.
So therefore, from 2000 to 2007, you will get the graduate scale
Up to 6 December.
up to 6 December. 7 December onwards, you will get the postgraduate scale
Yes.
under 98 rupees.
90.
Then under 2009 ROPA, it has to be worked out like every other employee. Nothing has to be. That is the correct position.
And Malad, if you take just one paragraph, page 79. I further say that is the impugned, that is why they are not paying. I for middle portion. Petitioner was appointed such and such.
I have marked it. I have marked it. Yes.
And 78, they are saying from the his date of appointment.
Yes.
In the case, instant case, petitioner gave higher scale of pay from date of his appointment. It is also not I am claiming. In 78, middle portion.
So they, as per their stand, they are skipping one stage. The graduate scale which you entered service with, they are straight away giving their next revision by virtue of 2009 ROPA with effect from 2006. The PG scale under 99 ROPA, they have not calculated. That is missing.
That is all. That is
So therefore, Actually, the question of law which has been recorded,
And that is also in my.
it is correct.
It's correct.
It is correct.
That is why even on that date, I consumed.
Whatever has been
proposition-
recorded on the date of this date,
Yes.
2725 in this case, that is correct. He did not acquire higher qualification prior to 2006. Therefore,
That is why
but then it says the provision omitted the provision for granting higher pay scale based on improved. Should it be where is that omission? There is no such omission.
and that is when I was not prepared to that one. My candid submission. Otherwise, on that date itself, I could have answered.
In 2009, does it say anything with reference to that 12.3? Any provision like 12.3?
I have checked it. Who were existing, they are to continue. But I was hearing one argument because on the Supreme Court, Raju Ramchandran argued, revision of pay, not exclusion. It must be revised of the existing one.
Has to be. That is the
Has
whole.
to be.
That is the whole
I
concept.
understand that.
In fact, there have been occasions where there has been a revision not from scale to scale but from post to post. In those cases also where there is no post, corresponding post in the revised, they had concept of need-based post, and based on that revision was granted. But nobody was to be deprived of revision.
This is all settled of the Honorable
The
Supreme
law.
Court. Scale of pay cannot be reduced by virtue of the continuation of the service. Now, we will also take that charge.
If it results in reduction, then they will get personal pay. It has to be protected.
But me, I place that charge itself. No, yes.
Yes, sure.
This he has got it as officer contingent. Then he acquired postgraduate 2007. So from 2007, he will get this master's degree holder skill. This is under this 98 scheme. Global activity 1998. So he will be required to get this from 2007. Once he got in the higher scale, 2 years after that, this benefit, Global 2009 came into operation. In 2009, it came into operation. Now 2009 gives you a revised scale for this. Very simple. Very simple.
Yes, you are showing something.
Yes. No. The paragraph 10, 30, 17, 20, 21, 26, and 30. These are the relevant paragraph. I don't need not enter. The picture was governed 1990. Coming from 1981, asked to Pakistan.
We can do this.
What is the meaning of paragraph 20? According to you.
And just follow from your lordship, interpretation of paragraph 21. Just your lordship said, this revise is to be correspondence to 90. 2009 also considered 96. And 30. Just now your lordship said what the interpretation would be.
Oh, the indefeasible right accrued to her will continue.
Of existing. 19. Answer.
Will be admissible to the appellant.
That is the consequence.
So what are the, he says point 1 and 2, where are the 2 points? One in the affirmative and 2 is answered in the negative.
There is no specific formulation of point, but answer
I was looking for that.
is also contribute to that. But answer has been given in the following manner.
So what is the negative answer? Which point has been answered?
He had objected to probably that just now submission of
That in 2009 there is no provision for higher qualification.
that is why this proposition has come from the notification.
Yes.
I leave it to Lordship.
Yes, reply please.
I know mine is a very bad case, my lord. I know, my lord. But only, my lord, why, my lord?
Bad cases give you an opportunity for good
Yes.
advocacy.
That is, my lord is giving me opportunity. I am
Bad
blessed.
cases give a lawyer a chance for good advocacy. When you have
My
a good
lord,
case,
I am
there's nothing to argue.
I am trying to my level best, my lord.
Try, my lord, always to assist the court. If some of the matters I concede. This cannot be. But I have learned this, your lordship.
And in this,
It is my-
my lord, in the appeal, it is my problem. The, my lord, the ground.
The question formulated in the order is correct. His lordship, Justice Sen's order.
I have just yes, my lord.
Correct, correct.
My lord, yes, that is the issue. My lord, that is the issue.
Now everything is clear.
Yeah.
You are saying something which was unbelievable and it was contrary to the affidavit also. Therefore, we could not.
May I give answer, but only 2 minutes.
Yes, you
My lord, kindly allow me.
Get 5 minutes. Forget
Yes,
about
my my lord, it is the first time I am getting, my lord, this, my lord, this indulgence, my lord.
Yes.
Before I do that, honorable do that.
Yes, please.
My lord, my lord, it is undisputed in 1998 ROPA there is a provision 12.3, including librarians. For acquiring higher scale, that is postgraduate scale, entertainment is there. But under the 1998 ROPA, he did not acquire his qualification, Malad MLib, that is Masters in Malad Library Science. But 1999 ROPA, Malad, if you also have a look, it would apply for teaching and non-teaching. Malad ROPA, it starts from A1, teaching and non-teaching staff of government sponsor aided school class up to 12. This is the actual case. And also, Malad, the teaching and non-teaching. Malad,
Don't re-argue what you have already argued.
Yes,
that is not the purpose of a reply.
he relied upon one Malad, he relied supplementary 86. What it says that 2005 one government order was issued declaring that librarian post of librarian is neither a teaching nor non-teaching post. 86.
Yes.
It is
Yes,
relied
yes.
my lord.
Yes.
So, my lord, if it is not teaching or non-teaching, then, my lord, 2009 ROPA would not be applicable in the case of the petitioner because he acquired, my lord, his master degree, my lord, 2007. When, my lord, 2009 ROPA came into force on 1/1/2009. 6, my lord. 1 on 2007, actually, my lord, it 1st April 2008. So he is getting, my lord, bachelor degree scale admittedly I have pleaded in paragraph page 77 in my he is getting 4500 9700, but in his prayer he is asking for 4650 corresponding 10175. That is prayer of the writ petition. Only lower tier there is a
Take your lordship book kindly.
150 discrepancy. Page 14 his prayer is for revised scale 4650.
You have not said anything about the Control of Expenditure Act.
Here I have flagged.
I have also given the my lord, act. A copy of the act I have given.
Yes, you have given us.
Fine.
2005.
Yes, my lord. Well,
Take the log, because I have flagged.
14.
This is the only ground in the affidavit. This is the only ground there. Nothing else.
You have to see prior to section 14. First, section 4 and 5. Applicability of the act to both parties. Here come 14.
My ground, my lord, ground number 4 and 10. But I admitted that this ground was firstly, my lord, raised in the appeal. কি করে develop করবো? এখন আমি ready করেছি, ওটা ওরা ready করে।
Yes. Appoint provide teacher is not other person.
No, he is relying on 14.
14.
14 in
14.
relation to the teacher only. Exclusion of liability. Because if the teacher is appointed to school service commission by virtue of 97 Act, their pay scale is to be governed by this act. Applicability of the act, not like.
See, teacher has not been given a watertight definition in this Act of 2005.
Yes.
Teacher has been defined in 2P. 1 to 2P. Means a teacher means an assistant teacher or any other person holding a teaching post in a school on a regular and whole-time basis and is paid from the fund under control of the. So it is not a very restrictive definition. So
Librarian,
therefore, is it in conflict with the definition contained in 98 or 99? Yes.
that is, if you are interpreting that as. And if you are
It is not in conflict. It is not in conflict.
not in, yes.
Here also it says teacher includes so many people. Here also it says teacher means assistant teacher or any other person.
Who is giving imparting teaching. Who is imparting teaching, not that other.
Now kindly come to page 86. 86.
And when if you takes this H,
H.
non-teaching staff.
Means a member of the staff other than a teacher of a school.
And if your lordship, why your lordship will get that 2009 teaching and non-teaching, my lord will get the answer. Well, after 2009, in the year 2009, these posts of non-teaching are to be filled up through SSC. First time gone there.
Librarian also.
Librarian also, includes librarian, page 115. Just now I am checking it up.
115.
Last flag, I am thinking about all this during the course. Subject to correction 115 last class.
Will take 5.
Oh, yes.
I know.
We have heard the submission.
Thank you. On 2nd, we'll pass the order. On 2nd February, we'll pass the order. We have taken note of the submission.
My mother is just now ill. That is why my ayah has called me. That is why I was.
Please go.
Grateful. I have left just for my secretary. He is just on next matter. He has told me item number 4 on today.
We have received a communication from him today.
Item number 4.
But in this matter, my lord, I am appearing on behalf of the appellant. But my lord, I need 1 week time. Why, my lord? Because my advocate on record never served the copy upon the state. And secondly, my lord, on the next day, my lord, it will take half an hour time. I will finish it.
Service is not required. Let us see. Even if they are not there, there is some. If we require, then we will ask them. Let us at least see what is the issue. Why it has been dismissed with cause. What is the issue?
My lord, the government for emergency and exigency acquired my land to construct one barn to protect the countryside by which the saline water in Sundarban area,
Acha.
the land was used. And my lord, after that, after overcome the flood and cyclone, Lord, my land not been released even today. And therefore, my lord, the representation was made seeking the compensation or the land. But the government said, you know, since the acquisition was not according to the procedure and law, therefore we are not agreeable to pay any compensation. But they don't want to release my land also.
Where is the prayer in the writ petition?
My lord, kindly come to page 11.
Oh, this is your appeal. We are asking you where is the prayer in the writ petition?
Yes. No, my lord, in the writ petition, page 11. In the paper book, my lord, page 11.
Oh, paper book. Sorry. This is part of the writ petition.
Fine.
No, there is no such prayer for. There is only a prayer for compensation.
Compensation.
Only.
Only.
Yes.
And my lord, kindly come to the order impugned. It is at page, my lord, page.
The order passed by the authority.
No, passed by the learned single judge.
Yes, page.
Page 60.
So how you can get a compensation in a writ proceeding? That is the first thing. Under which provision? Under which law? The writ court is to direct for granting a compensation.
Yes. My lord,
For acquisition of land, which you say is acquired.
Lord, on the next day today, I am not. I have no way.
That is the only issue.
Yes, this is my lord. Article 300 capital A says that the moment the authority or government, although it is not fundamental right today, but the royalty land when the government will take over, either the government will pay the compensation, even there is no acquisition proceedings.
Even if
there is no acquisition proceedings, but since the
Article
land,
300A says even if there is no acquisition
yes, my lord,
proceeding.
there are plethora of judgment, my lord, on the next day I will place. Then, my lord,
Article 300A manifests in the Acquisition Act.
Act.
Now, as per the Acquisition Act, there is a remedy, there is a way. How it can be done in writ petition? That is what we are saying.
Lord, kindly visualize one situation.
Yes, then everyone should come here.
Should, as per my idea, my lord, should come to the court. Why? My lord, the government took over my land for exigency purposes.
That you are saying.
My lord, the government said this in their affidavit in opposition. They said this.
Yes.
Kindly come to their affidavit in opposition.
Yes. What have they said?
Yes. Lord, kindly come to page 40. It starts from page
40.
40. Starts from page 35, the affidavit in opposition. The relevant portion is page 40, paragraph 7 and 8.
Just give us one. 7 and 8.
Paragraph 7, my lord. That with regard to paragraph number 3 of the said application, I deny and such and such was necessary at the time as the land of concerned area was subject to engulfment by the river Gobadia. Local people and the landowners whose lands were affected also requested to department to take up immediate measures to protect the lives and properties and cultivated land. They admitted it.
No, they didn't. You say they took over. They are saying the people asked us to do this. Please do it on our land. The two are two different things.
Lord, my lord, for the
There is no
purpose-
admission.
my lord,
Yes.
for the purpose of taking over the land
Therefore,
to protect the villagers.
ultimately the issue will arise or is arising, which arises is in a proceeding under 226, a disputed issue whether it was acquired or given voluntarily, and what is the compensation, who is the rightful owner, title, everything should be examined and a compensation given.
My lord, kindly. My lord, the local people
Maybe.
may asked and requested, delivered.
Yes. So who is that local
The
person?
land is not belongs to the local people.
We
Land
don't know
belongs to
who.
me.
We don't know. This is not the forum for looking into. That is the only issue that we are saying.
In their affidavit in opposition, kindly have a look into paragraph
Yes.
7, 8, 9, 10.
We have seen 7. 7 does not solve the issue.
Next, 9.
Yes.
I further say that, paragraph 9, fourth line. I further say that the soil of this deltaic zone is highly unstable and subject to frequent change with the change of river course. Such engulfment of land should be construed as an outcome of national calamity. The lost land cannot be considered as land taken over.
Correct.
Lord, the government possesses my land, constructed.
You are inserting my. There is no admission anywhere that it is your land. Their stand is that there is a saline water here. The local people said that there is erosion. Take some steps. They have parted with their land. They have asked us to do something. We have done it. Who are those local persons? Whether it is your land, you are part of that. There is no admission. Who is the rightful owner of that land? Now that land has gone under the sea. How much extent of the land was there when it was taken up? Whether it was 10 feet, whether it was 5 feet. Now there is nothing there. And this has been done decades back. All of a sudden, one day you come to the High Court and say, direct for giving a compensation. That is the problem. It cannot be looked into in a writ proceeding. Cannot be.
Writ petition is maintainable, my lord, for taking the compensation.
We are not on that. We are not on that. We know Chandrima Das, Chairman, Eastern Railway Board, all those concepts of compensation in writ proceeding. We are also conscious, subject to further assistance from you. We can see. But in this case, there is no case whatsoever which can be resolved in a proceeding under Article 226. You are saying my land has been taken over. They are saying it is not your land. People have given this land. We have done this. Compensation, how it can? Impossible.
The responsibility attributed to the state authority at the time of constructing the bath to look into whose land over which they are constructing.
When it was done?
They are
When
responsible.
it was done?
The,
When it was done, sir? Please tell us.
the period is question, whether limitation is.
No, we are not on limitation. Sorry, we are not on limitation. When it was done?
Yes.
Where is the question of limitation in a writ proceeding?
Arey bhai.
There is no question of limitation in a writ proceeding.
Not it is in the year 2012.
Yes.
Representation also filed in the year 2012. 2000 page 20.
It is not 2012. If we remember correctly, it is 2000, 2001. You have filed a representation in 2012. You have filed
2012 the representation was made.
Yes, but the cause the whatever has been done was done long back, decades before that. There is no scope for anything to be done in a writ proceeding.
In West Bengal, my lord.
So only issue is of cost. Only issue is of cost, whether the cost should be maintained or not.
No, my lord, whether
Yes.
the land losers, whether I am coming under the definition of land losers or not, my lord, in West Bengal, your lordship knows very well, perhaps, there is the direct purchase policy system.
That's not arising here.
My lord,
Yes.
for the purpose of exigencies,
Yes.
the government can take over the land
That's
and
not
the
arising.
land is used. My lord, they are not telling this that we are not using the land of the petitioner.
No, they have never said that they are using your land. They are saying local people have given. There is no admission that even 1 inch of land of yours has been touched. Who are those local peoples, whether you are one of those or there are hundreds others?
My lord, it is
Nobody knows.
It should be looked after by the authority.
Not in a writ proceeding. Therefore, we are again and again. It cannot be done. It cannot be done.
Yes, my lord, I will come back next day. My lord, I
What
have
come back? This is the case, nothing
not-
else. There is nothing else. Some cases, there are limitations.
limitations and maintainability, my lord.
No, not limitation act. I am saying there are some cases, there are limitations of jurisdiction. 226 cannot be invoked in these facts.
My lord, on this point, my lord, I will argue on the next day.
What
I
is
will
the
argue
fun in
because-
the next date? You are arguing today. You argue. Why next date?
My lord, I am not well equipped today.
No, because we have adjourned it earlier. We said we will not adjourn it. We don't appreciate this. When we have said we are not going to adjourn again, why?
No,
This
sorry.
we don't appreciate. Because we have said, we have looked into it and we said, no, you please put 1 day adjournment, my lord, and then again adjourn.
And my lord, next week I will finish it, my lord, next week.
Not today, it will come on the next day.
But only the point is how the read code will adjust.
Only point is cost is to remain, be removed or increased.
I don't believe this. Grateful, my lord. Happy New Year, my lord.
Happy, very happy. Number 5.
Lord, the case as to this transfer at his own volition, my lord, as I was arguing, my lord, 99-2. Now, my lord, if your lordship kindly remembers, my lord, the question struck as to page 79 of the writ petition. 79, which, my lord, as if of the petition, my lord, it's 79, which, my lord, there is a notification from the railways, my lord, that those who obtain own volition transfer, that 8 years they will have to spend in that zone itself to be entitled to have a promotion. Now, my lord, the question arose, my lord, that whether that can be a binding, because the Schedule 4 of the RPF Act provides only for 8 years and not for that transfer all these things. Though 99 speaks of that it will come to the bottom scenario, my lord. Now, Lord, I would refer first the one of the Railway Boards Act, my lord, which, my lord, I will two sections of the Railway Board Acts, my lord. Lord, this, my lord, I'll just read two sections, my lord. The first one is, my lord, section 2, my lord, investment of Railway Board with powers under the Indian Railway Act 1919. The central government may, by notification in the official gazette, invest the railway either absolutely or subject to the conditions with all or any of the powers or function of the central government under the Indian Railways Act 1890 with respect to all or any of the railways, and with the power of officer referred to in section 47 of the said act to make general rules for railway administration by the government. Then, my lord, paragraph 3. Paragraph 3. Section 3. Any notice, determination, directions, requisitions, appointment, expression of opinion, including expression of opinion, approval or sanction to be given or signified on the part of the Railway Board for any of the purposes of or in relation to any power or functions with which it may be invested by notification under section 2 shall be sufficient and binding if it is written, signed by the Secretary of the Railway Board or any other person authorized by the said Railway Board to act in its behalf in respect of the matter to which such authorization may relate. And the said Railway Board shall not in any case be bound in respect of any of the matters aforesaid unless by some written signed in manner aforesaid. So it has to be signed, even the expression of opinion. And Lord,
Yes.
now, my lord, here, my lord, I'll refer three judgments which was also referred before the learned finish. The first one is a Guru Pratap Singh judgment concerning this 1992, my lord. My lord, this is the judgment. Sir, Guru Pratap Singh, Guru Pratap Singh judgment. Lord, here the case was that not following 1992, the own volition transfer was placed above some amount. So the fact, my lord, we'll find out in paragraph 10 of the judgment. My lord, paragraph 10, my lord. It is an unreported judgment. Lord, Gur Pratap Singh, my lord. para 10, my lord. It is page 4 of the 6. My lord, this is the fact. According to the petitioners, in November 2006 and 8, a large number of constables from RPSF were transferred to Firozpur division of RPF on their own request. It is stated that on 5th July 2016, a seniority list of the constable in RPF Northern Railways prepared by the respondent number 3 was circulated to the post commander, Firozpur division. The said RPSF member who had to be placed below the RPF members already working in Firozpur division in terms of rule 99(2), my lord, I have shown it on the last day, of the RPF rules were however placed above them in the seniority list. Now, my lord, paragraph 15, my lord. It is, my lord, I found out paragraph 15.
This is precisely what we are saying. This is precisely what we are saying. It is only determinative insofar as the seniority is concerned. It nowhere speaks of obliteration of the past service or counting of the past service for other purposes. This is precisely what we are saying. This is not at variance with what we were observing.
My lord, it is where if the my lord, I'm just my lord asking it to myself, my lord. If somebody is placed below, all of the rank is placed below. So, my lord, their promotion is according to that rank, because then they will have to rise up.
Surely, there is no ambiguity on that. They cannot contend to the contrary.
And my lord,
Once they have chosen a seniority position, they cannot get exalted. But their qualification of 8 years cannot be obliterated.
my lord,
They may
here-
not be promoted till such time the last person above them is promoted. But their qualification will not be obliterated.
my lord, here,
The
my lord,
two are completely, this does not answer the court square.
my
This
lord,
is precisely what the court is saying, what we are saying.
yes, my lord, but my lord will kindly consider now reading this with that page.
So ultimately, you will come to that letter written by the DG or DIG, whoever it has written, of the board.
Railway board that speaks of that.
Maybe. So this is answered.
My
This
lord,
is answered.
here it is answered, it should go. But that 8 years has not been dealt with here. But
Cannot
that-
be. Cannot be.
That has not
cannot.
been dealt with.
It
We have
cannot be.
stated that it will go, my lord, at this bottom seniority. Now, my lord, this is there. The other aspect is that this is, my lord, or not disputed that they will go and will raise according to their
See,
seniority.
as when the matter is being argued, subject to what they may say, as far as we have gathered from the records, they have got a choice transfer. They know it comes with a sacrifice of their seniority. They have sacrificed their seniority and only seniority. They have sacrificed nothing else. That is their case. You say no, your seniority is gone, plus your entire past service is obliterated. Now it will start afresh from where you are. This is the sum and substance of your submission. This is a bit.
This is the rules or the, I would say, my lord,
That communication says so.
Yes.
That communication, what is the?
This with the Railways Act, my lord, it stands, my lord, subject to your lordship's consideration. My humble submission, it stands, my lord. So, my lord, then two questions are also of the same. I'll just show one of the paragraphs, my lord. That one judgment, two judgments were referred. One is according to the equity cannot stand over the law.
But this does not deal with that issue that you are canvassing.
No, my
This
lord,
does not
here
deal with.
canvassing, my lord, specifically that issue, my lord, is nowhere dealt with, which judgments were referred.
So
that was
in
not
the other judgment, it is there.
The judgment is not also there, but paragraph 15, 16, I would refer, my lord.
Of that judgment.
My lord?
Of this judgment.
No, my lord, the other judgment, AIR 2008.
That's not an issue arising. What you have just shown is not an issue arising.
Paragraphs. My lord, I'll complete that because that is what equity when. My lord, now, my lord, the paragraph, my lord, 21 and 20.
And which paragraphs in this judgment?
In paragraph, my lord, 10 and 15, 10 is the fact and 15 is the ratio. 10 is the fact and 15 is the ratio. And here, my lord, paragraph 21 and 22.
Just give us a minute.
Taking paragraph 22 and why I am asking for, my lord.
We don't read judgments without the facts. Please allow us to go through the facts. Yes. Yes, which paragraphs?
Paragraph, my lord, 22. And why I am asking for, my lord, paragraph 22. Because judgment AIR 2008 Supreme Court once again, sir, judgment. Kumar Sharma, sir, Kumar Sharma. Kumar.
Yes, 22.
My lord, why am my lord pressing upon me? My lord, in my opinion, because of section 2 and 3 of the Railway Code Act and because of the notification which has become a statute. So, my lord,
It's become a statute.
my lord, it is binding.
It is a notification. What are you saying, statute?
Binding, my
You
lord.
are exalting it to a statute.
My lord, it is
Binding on the courts. What are you saying, sir?
It is binding, my lord.
It is a notification. It's not a statute by any sense.
My lord, now, my lord, exercising, my lord, I would say, my lord, it has to be exercised in the way that it has been.
It is an executive.
the
It is
ratio.
like an executive instruction being issued by the central government. It's not in the least a statute.
My lord, now, my lord, that is what I'm. Why 22 is because that will be binding and my lords, and that my lord, that is binding. I would say because of that aspect.
Obviously, on you it is binding. That we know. We are not to be told. But you are trying to read it as if it is a CPC by relying on this judgment. There we have some difficulty.
Now, this is what the submissions are, my lord. This is one aspect is they are given the promotion chronologically from the bottom seniority. They have risen, they have qualified, and then when they rose, when their turns come up, they are given all given promotions. Now they are all inspectors. So that is not a denial. Say rose according to the.
No, one question we have from you factually.
Milord.
The last person above them, when was he promoted? If he is at seniority 10, hypothetically, when was the person at seniority 9 promoted? What is the gap? Is there any gap? Is that fact anywhere there on record?
Milord, I'm coming from my.
No, we are in the meantime. The person just above you, in seniority, between his promotion and your promotion, what is the gap?
3 years.
Where can we get this? Is there any dispute regarding this 3-year gap?
Milord, I have told my client. Client is present. I'm told my client to inspect.
The bathroom were all only 40,000 they are junior to us. But at that time, we have completed more than 8 years service. We have not qualified. Our prayer is this, that according to the notification, we have become entitled to this. So you should call for restriction. We are not for restriction. Our prayer is this, that we are entitled to, according to the rule for that we have completed more than 8 years. It cannot deny our service. So, the year we are not. You know, if we are being promoted, our
In this list of eligible sub-inspectors,
yes.
this is of which division? Where you have been transferred. So which of these persons is below you in the seniority in the Eastern Division?
They are Eastern Railway, they are our seniority placed in the bottom. So they are above us. That is why they have been called for.
So they are all above you.
Above you in the Eastern Railway.
All these 14 persons.
But we say that your qualifying option is 8 years regular service. We have completed more than 8 years than this person.
And this is for how many vacancies? In this division? It is division wise or it is? So against 53, they are promoting only 14.
Notification dated August 2018 on the 30 scheduled class. We are also scheduled class. We are up to scheduled type candidate. Only 2 or 3 candidates.
So this is the order which was challenged before the.
The report direction is that consider their promotion according to this. Last 106. In view of the discussion made above, the action.
No, first of all, we are trying to understand why against 53 they have called only 14. Is there a quota out of this 53 to be? It is a by way of direct recruitment. Also, inspectors are appointed.
But, at that point of time, whether there was 53 vacancies or not, that we have to ascertain.
No, page 66. It says so.
Yes, Milord, but 53, why 14 has been, Milord, that 14 is page 68, Milord.
A list of 14 who are eligible. Oh, so according to you, only 14 were eligible.
Milord, आपने 14 को ये लोग को ऐड किया एक तो वे उसी तरह
Just. Where is this communication of 1st January 2018?
No.
1st January 2018 communication is at which?
First.
That is at page 78. And 10th January? Where is the 10th January communication?
Yes, reference to 1st January and 10th January. Page 78, Millard.
There is a corrigendum to page 78 on 10th January. Where is that?
But Millard is referring to each paragraph, Millard.
And page 6 of the single judge order, second paragraph, page 6 of the learned single judge order.
By corrigendum dated 10th. Yes, my lord. That is there, my lord. My lord, that is 56. 56. Then, first, 10th January 2018. Yes, my lord. This is the corrigendum, my lord. I have found. This is, my lord. Can I show it from the file, my lord? This is
It's not on record.
not a record, my lord. I can show it from the file, my lord.
Give us a copy, don't show it from the file.
My lord.
How can we consider unless we see? Because how the honorable single judge has taken note of that.
Most probably, my lord, it was shown at that time per time. Most probably.
What is the corrigendum?
This is the corrigendum.
Give us 2 copies. Because it appears that what the corrigendum has enforced the rule of seniority only. The facts we had seen on the last date. Please just help us. Where is the rule under which the promotion is conducted?
The promotion is schedule 4, my lord. Schedule 4, my lord, is my lord, this schedule 4, my lord.
Para 4. It is in the RPF rules.
The RTF Act and rules, my lord. Yes, my lord. RTF, my lord, I put a paper in that schedule 4.
Victim Protection Force Act and rules. Thank you. We have got the book. Thank you. So is it your case that this communication of 1/1/2018,
my lord.
even if it is in conflict with the rules, it will prevail?
1/1/2008, 1/1/2018.
Yes.
My lord, as per clause 4, my lord, that period of 8 years is to be completed in that zone because of the own request.
No, but what if it is in conflict with the provision contained in the rule? Which will prevail according to you?
But if the rule will prevail. But conflict is, my lord, here, my lord, I would say, my lord, the any modification as per section 3 of the railway board, any modification that is being brought in become effective, my lord, subject to a lordship consideration, and that modification has been brought in because by way of this board, and this becomes binding because of the
Therefore, we asked you. We have understood your Railway Board Act. That submission we have understood. You are saying if it is signed, authenticated in the manner specified in the Act, it is as good as a notification issued by the central government. So by notification, can the central government interfere with the rules, RPF rules, framed under section 21 of the Act, which has been laid before both houses of the Parliament?
this.
This is the only issue arising. See, this is the core issue. Everything stems from this only. You see, please, section 21 of the Act, RPF Act, 21(3).
RPF Act. Central government by notification are free. Email of that. My lord, I'm reading through, my lord. Every rule made under this act shall be laid as soon as maybe after it is made before each house of parliament, where it is in session for a period of which it may be comprised in one or in two or more successive session, and if before the expiry of this session, this is all for all acts, my lord, this comes up.
So this is under section 21, the 87 rule has been framed.
Yes, my lord. But my lord, if your lordship kindly also takes up that 21, 2,
Yes.
and then C, my lord.
2C.
2C.
Yes.
And 2F. To see, my lord, fixing of the period of service.
Correct. Like that's precisely what we are saying. Period of service, the rule making power vests in the government to be done in accordance with section 21 after being laid before both houses of parliament. So the Railway Protection Force rules 87 is made. The period of service is fixed in the schedule, laid before both houses of the parliament, saying 8 years. Now comes a communication issued by the railway board that you count this 8 years afresh once he is transferred.
This is what the case
This is the issue is. This is what the issue is. But the Honorable Single Judge has taken note of that 10 January because it appears that there is something touching upon this issue. If you read that second paragraph at page 6, you will see why we are saying so. Just have a look.
By a corrigendum dated 10th January 2018.
Second paragraph at page 6.
Second paragraph. By a corrigendum dated 10th January 2018, the aforesaid direction was changed, and the same was read: an enrolled member of the force who has come to the zone and transfer from one zone on request or mutual ground shall be considered for promotion in the zone only after the candidate placed above him in the.
This is exactly what we have been saying.
I understood it.
So
it according to the severity,
so therefore, if it has been already modified by yourself within 9 days, then why you are making it an issue? On 1st January, you say something, and on 10th January, you say something else. After 9 days, and what you're saying after 9 days, we have been saying from the beginning. So if that is the position, then therefore we want to see that. That's very relevant. Then the entire objection will go.
My lord,
Because that appears to be the only, according to us, you are making your submissions as per instructions, we understand. Otherwise, it is preposterous. Then you should say that if you want to be transferred, you will lose your past service. Not only you will lose your seniority, you will lose your past service also, for all purposes. He didn't go with that rider. He only went losing the seniority. You get it? We are coming back. Just get it. You share it with him also.
yes, my lord.
Yes.
I've told him to make 4 copies. Two
Because-
for my lords and one for Mr. Merchant.
Supplementary list item number 1.
Please to yesterday, last month, please to directly file a compilation. Oh, yes, give it, give, colored back. Supplementary.
Original side is তুলতে নাই next side is
You intimated the other,
For the petition.
you intimated the other side.
I have intimated, my lord, the usually Miss Debolina Ghosh appears. But when
We asked him to intimate.
when we went to intimate to Miss Ghosh, which was we were informed that she is not in a position to accept it. That is the difficulty we had to face.
He told me that he has informed.
Yes, he went.
He should have said this. He got it listed as if everything is done. We asked him. We have given precedence over the original side matters.
But
We want to rely on you when you say something. We want to rely on you. We want to.
We did inform, my lord. There is an urgency, my lord, involved in this.
What urgency? In their absence, what we will do? You have 13th. We said we'll keep it on 13th. No, keep it today. I will inform. I have informed. I said, come back at once. He came back. He said, yes, I have informed. This is not appreciated.
And ultimately, GP has been informed, my lord. GP's officer.
So you know who is to take steps, if at all.
But
What he will do?
when a GP mail or a health
That's not the point. When you mention, when we ask you to do something and you can't do it, then why should you tell us that you have done it?
I'm sorry, my lord.
You didn't tell us this, that she has not taken the notice. You said, I have informed her she is on legs. Please don't do this.
My lord, I'm sorry, my lord.
We'll stop taking slips from anyone now
It's my
for 2 p.m. Anyone.
my lord. It's my. I should have. I will.
At
I
this-
take the responsibility.
At this young, when you are at a youngest age, this is what you are doing. Very nice.
I find that the leave was granted to file it without the certified copy. The letter says that your lordship has fixed the matter at 2 o'clock. So I just was the urgency and I got it for just 10 minutes.
This is not appreciated. This is not appreciated. The whole system rests on some bar and bench relation and some trust, mutual trust.
But I
I have not been able to open the brief.
You cannot pull a fast one. Don't ever think of it. You have a long way to go. At least with this court, you will not be able to do it. At 10:30, we told him, please make sure. He came back. He said, I have informed her. She's on legs. You could have said that she has not accepted. Suppressing facts and getting the matter listed, that itself is enough to decline any relief to you.
Can't come to me. You have to go to my office. I was on legs in another court. He said, I went to you. What is this?
This is not done, sir. This is not done. You are a lawyer. You are not the party.
my lord, I will tell him, my lord. He has long way to go. He will learn.
By doing such things, you undermine your own
Yes, my lord. All right.
for all times to come. Let us see what it is.
Yes, my lord.
Whether there is anything or we should do.
I am only aggrieved by this. I got the certificate.
He mentioned that there is a advertisement for pharmacist appointment, which requires a registration with the council. They were having registration on the date of advertisement, but it has not been accepted.
Yes.
Now let us see the registration certificates of all the petitioners.
Kindly come to registration certificates, my lord. These are starting from page
What is
number,
the last date for submission of forms?
my lord, 9 September, my lord, was the last date, which starts from this advertisement is in page 46, my lord.
Not 9 September.
3rd September is the date.
Last date.
Between 13/8/2025 to 3/9/2025 till 2 p.m.
So where is the certificate of 3/9 which is in existence on 3/9/25?
My lord, page 100 is the petitioner number 1,
100.
page 100. Page 100 is for petitioner number 1, Goirik Debnath. My lord, West
No, no,
Bengal
this is only up to 31st December 23. This is not on the date of 3/9/25. This is up to 31st December 23. He has no certificate on the date of application.
My lord, this
Yeah,
now there is a provision of the that is the question of law which has to be decided.
What question of law, whether he can participate when he is not having the qualification? That is the only issue for consideration.
My lord, I have the qualification. It's a question of renewal.
It is not. It is a qualification valid only till 31/12/23.
My lord,
It is so many in so many words stated in the certificate.
My lord, kindly come here, my lord.
Please read.
This is to certify that who was such and such registered under the Pharmacy Act 1948 under number such and such, but whose names was removed under subsection 2 of section 34 of the said act, has fulfilled the conditions referred in the provisions of the subsection, and that his or her name has accordingly been restored in the registered under the same number. This is to certify that above named pharmacist having complied with the requirements of section 34 of the Pharmacy Act 1948, his registration has been renewed for the period of such and such. So now it is renewed.
So again, it is removed after 31st December 20.
Page 99, Lordship.
It is quite obvious.
Kindly come to page 99. Date is 7th November 2025.
That cannot be relied upon. That is much after the cutoff date.
No, now, Lordship, this is the
That is much after the cutoff date, sir.
advertisement, Lordship, does not contain that provision.
It does.
The renewal.
It does.
Lordship,
Advertisement says a registered.
Registration.
So there is no registration.
I am registered.
No, you're not. Sorry.
My lord, I'm asking this question to myself, that this registration is based on the qualifications.
Sir, there is a registration which is apparently from the reading of the certificate valid for a particular period, and then you are removed from the register.
No.
When you renew again, you are inserted in the register.
Kindly,
Then again you are removed from the register.
may I request your lordship to come to page 47 once?
You take us to as many pages as you want, but the
47.
certificate will not change, sir.
Yes, my lord, kindly qualification.
Yes.
And here, 2 years diploma course in pharmacy.
That is not an issue.
Recognized by the government.
That is not an issue. That is not an issue. Those issues are
And registered A category pharmacist.
correct. So whether you are registered on the date of
I
application,
am registered.
you are not, sir. You may say so. We don't find it.
But lordship, if I say that once I am registered,
You may say whatever you have just read the certificate. Can we just ignore all that?
lordship,
That it is removed from the register for not renewal.
that is lordship certificate of restoration. And now it is
Correct.
restored.
Correct. So if it is not restored, you are again removed. What can be done? Nothing can be done. All the petitioners have the same certificate, or anyone has it on the date of 3/9/25.
Everybody has that common ground.
Then nothing can be done, sir.
Now this registration, my lord, this renewal can,
That's not the issue here.
can they be denied to
Whether
participate
today
in
you
the
can be
exam?
allowed to participate when you don't have the requisite qualification on the cutoff date.
Now,
That is the only issue.
lordship, before I file the matter before the West Bengal Administrative Tribunal, lordship, they changed the candidate status. Once we filed it, lordship, kindly see the status.
That is not arising for consideration today. Whether you are to be allowed to participate or not, that's the only issue today.
Lordship, may I demonstrate in this way? Today, I have a certificate which shows that I have.
You have been saying that, but we don't find you have a certificate.
But this document says that I have the qualifications under section 34.
That you are saying, yes.
But
We have understood your submission.
so, lordship, that is the prima facie case I have.
All right.
Advertisement does not include the requirement of renewal.
All right.
Now I have the qualification. Now what would be the corollary if I apply for the renewal?
We are only whether an interim order is to be passed. So
that-
prima facie, a case can be made out the moment you show that you are fulfilling the requisite qualification as on the last date.
Yes, my lord. This
He made a
qualification was-
specific submission while making mention that we all had the certificate on the last date. Therefore, the first
I
question we
have
asked,
certificate of the last date, pharmacy certificate.
you have a certificate, but a lapsed certificate.
No, the
Nobody is saying you don't have a certificate. You
no,
have a lapsed certificate.
Lordship, the renewal, can the renewal, the status will change this position. The requirement under the advertisement is 2 years diploma course in pharmacy recognized, registered as A category pharmacist. Yes, I was registered. And now if I make the application for the renewal, it is the inevitable result that it would be renewed. Now, Lordship, kindly come to another page, 306.
We are asking you first, is any petitioner having any better situation?
All of them. And only thing, Lordship, 302, 306, there was the requirement from the Health Recruitment Board, which says that it is hereby notified that all aspiring candidates who have applied online for the post of pharmacist grade 2, write advertisement number such and such, dated 7/8/2025, and whose applications have been rejected due to mismatch of information, want of required documents in essential segments of the concerned advertisements, are allowed to resubmit the relevant information documents in the respective segment within a limited stipulated period, with reopening of the requisite link for the such candidates to upload the relevant.
Where are you reading page?
Page 306, my lord. It is to be noted that such candidates, the resubmission of the information or uploading the documents has to be done through the online portal only. Hence, resubmission of the prayers of the documents in physical form and through email will not be accepted. Now, there was a notification from their side which was dated 9/12/2025, by virtue of which it was notified that they can resubmit. Now, Lordship, kindly come to NB. It is to be noted that no particulars and certificates.
No, this is for submission of documents, not for acquiring the essential qualification.
No, they have never used the word renewal. The only thing
that we have already said.
The question, the term, your Lordship.
That we have already said.
I'm borrowing the word from your Lordship. Your Lordship has said that acquirement of the qualifications.
Yes.
Whether
Not acquirement. Possession of the requisite qualification on the last date.
Now, last date, Lordship, requisite qualification is the pharmacist. I am a pharmacist.
Now you're saying the same thing repeatedly. You have said three things. One thing you have said that we had the certificate, it was only not renewed. Two, you have said that the renewal was never required under the advertisement. Three, you are saying they have given a window. These three things. Anything else?
So kindly, I am only saying that I have a prima facie case. Allow us to participate.
We are being very clear. We don't find a case. Yes, take down. The petition. Please, certified copy is taken on record.
We are not here to advise you, but again, we are advising you, don't do this. Don't do this.
What the address?
Millard will be taking our matter.
All right, let us complete. Yes, give it.
Millard, this is the notification of Millard 10/1/2018.
If no submission is to be made, then we can just take it and don't do matter. But since he has seen it right now, he may want to make submission on this.
Then Millard will come back.
Or when? Just go through that. 10 January. When should we have it? Next Wednesday. Wednesday. Yes. Is the day. Wednesday is all right.
Millard will be requiring the book I have given.
No, we have please return his book. We have
Return the book.
Thank you.
Return the book. This book.
For considering.
Millard will be passing some order to the
Yes, we understand. Not we don't understand. For considering. Oh, sorry, it cannot be on 14. There is some uncertainty. Then instead of 14th, we can keep it on 16th is working. 16th. 16th is all right. Right. 16. 16.
Original side matter item number 1 and 2.
1 and 2 arising out of the same judgment, but Mr. Ghosh is on the other side. I think Mr. Ghosh is. Yes, my lord, this is Kali Thangar, this matter, my lord. In this matter, my lord, your lordship directed.
Yesterday, the matters which we had.
No, those matters are different, my lord. It's a very small matter, my lord.
Wage agreement.
Yes, wage agreement relating to MMCC. It's only a period of MMCC which to be considered. Your lordship, on the earlier occasion, your lordship directed us to take steps so that the admitted amount to be released.
In that case,
Yes, we have already taken steps and released within 3-4 days. I think so, by of 5-6 days, because they had submitted their bank documents.
then let us keep it after a week. You ensure that is done.
Yes, yes. We all, otherwise, Mr. Ghosh is also not here, my lord. He also
That's
requested.
why we are saying.
Yes, yes.
We are informed. Please take down.
1 and 2, my lord. 1 and 2, my lord. Combine both, my lord. Your lordship passed that order of 11th of December.
So that is done. Any other case?
3 and 4 is Mr. Bhattacharya's.
Now let us see 3 and
That's
4.
different.
This is in 1 and 2.
This is 1 and 2.
Here. Yes.
Item number 3 and 4.
2013, 2014, she made application, but DCL take a bill. Where you understand that they never received this application.
So he has relied on that Bauri judgment. The learned single judge has relied upon that judgment.
Yes.
Maya Bauri judgment.
Bauri, I am relying on 3 judgments of Supreme Court.
So Maya Bauri we have already taken up. Let this come along with those matters. We know you are relying upon judgment of the Supreme Court. There are 2 judgments, other judgments in the case of one Sumi.
There is another judgment, my lord.
And another
Dukhini Bhuiya.
Bhuiya, yes. So
Dukhini Bhuiya, I am relying on Supreme Court judgment.
So let it come on that day only.
Dukhini Bhuiya,
Same issue is being argued.
thus appeared before the Honorable Division Bench. That matter went up to Supreme Court. I am relying on that judgment. Where Supreme Court says from the last 3 preceding year you should give.
Supreme Court says that individual facts of this case.
Understood. Right. I bow down.
We have already seen that judgment. Yes. Anyway, it will come. See, all are to be considered after Maya Bauri. Therefore, Maya Bauri we have already fixed. When have we fixed that? What is that number of Maya Bauri? So let us have these matters on 20.
3 and
Can
4
you give
maybe?
us the number of Bauri?
Which one?
Bauri, what is that number? The other case, Maya Bauri number.
Bauri. ঠিকঠাক বল বাবা ভুল হয়ে গেলে
29. Take the case number so it can be listed.
No, I don't have. 29th?
All right. Take the intra-court appeals arise of
Item number 6.
I have to respond.
In the morning at 10:30, I have been served with a copy of the opposition. And I shall file reply. So I'm saying.
You have been served with opposition. You are respondent.
I'm responding. Copy of the
Appellant is filing in opposition.
I filed one application
For
for taking into consideration some important facts. But my lord,
let us see.
the respondent was a writ petitioner.
Yes. So what is the problem? It is essentially an amendment.
No, my point is,
Sir, can 5 is essentially an amendment.
no, not amendment, but
It is an amendment. You want to add certain paragraphs to the writ petition. So it is an amendment.
I did not file any application for amendment.
Please see what is your prayer at page 10 of your application. Please read.
Sorry, man, the population not with me at this point.
You don't have anything.
I am sorry, I have got it. I could do it.
Not today. Affidavit in opposition is taken on record. You are appearing without file. Very nice. Matter is adjourned for the day.
Wednesday. 13, 14. Item number 7.
Here on behalf of the appellants, her certified copy was applied on 24th December 2025, my lord. To obtain the certified copy of the memorandum of appeal so that I can, it is a change brief, my lord.
Oh, who is the appellant?
Appellant, last occasion, Mr. Deepjyoti Chakraborty.
No. Who is, which entity is the appellant? A private individual?
No. Vibhas Saha to appellant. Writ petitioner, my lord.
Individual is the.
My lord.
So why he doesn't have a copy?
No.
Then what do you want? You want certified copy of the records?
Pardon, my lord. My lord. And kindly direct them to expediently given me.
Application today. Where is he? You say change brief, then somebody must have filed a wakalatnama. What is this, madam?
I have been instructed to.
What instructed? You ask him to be here, huh? It was sent. No, that was another case. That was another case.
If I does the department party check.
No, this one, no, that was another case. We had sent it.
It was another case. I remember he has already got the copy. MS so and so submit.
কবে আসবে ম্যাম? 3 weeks. Date, 4th February. একটা এক্সট্রা লিস্ট নিউ ডিপার্টমেন্টেও যাবে, ডিপার্টমেন্টে যাবে তো। Item number 8.
8, my lord, I am appearing for the petitioner, my lord, which has been tagged, my lord, by the honorable Chief Justice along with 3 appeals, 8, 9 and 10. My lord, on the last occasion, 3 appeals, my lord, were referred by the state respondents.
Lord, so far as item my lord 8, 9 and 10 my lord. The last occasion my lord, the matter was called on by your lordships my lord.
Was
the-
last occasion?
On the last occasion my lord, I find from order sheet dated 2nd January my lord, none appeared for the state to assist your lordships my lord. Since my lord, the learned pockets my lord are no more my lord in the panel. So my lord, yesterday my lord, I have been informed by the learned this legal remembrancer to my lord appear in these matters. And today I have got the approval of my appointment, but it is briefs not yet received, my lord. So may I pray for my lord? May I pray for a fortnight's accommodation, my lord, so that I can assist your lordships? my lord?
Something.
Not representing the respondent have been referred by the state. If the chief of Ghosh, my lord, is appearing for the respondent in those appeals. But I am, my lord, appearing for the writ petition, which has been tagged. In this writ petition, my lord, the learned senior standing counsel, so Shivchana Bandyopadhyay is here.
No, what we are saying is, we have understood what you are saying. You have a separate case as distinct from his case. There must be some commonality why the chief has directed for tagging. So if he is not in a position to do it today, is there something which is going to happen, or you can wait? So let him.
These 3 appeals, my lord, I have been engaged by the learned legal remembrancer.
Understood, sir. Understood.
Kindly give me some
So
time.
if there is nothing pressing, then let it come after he has the brief.
Lordship.
How much time?
May I pray for a fortnight's time, my lord,
Yes,
so that I can assist your lordship, my lord.
Mr. So-and-so is.
कोण appeal आहे तुम्ही? Item number 11.
Hmm. 28, 28 January.
Not cutting instead of. Right. तो बोले वो कैसे
Yes, but my lord, a short pass. My brief is coming.
Huh?
Means the brief is coming, my lord. Taking some. I should be kindly recall, Lordship has taken this point that whether you have a locus to file a writ petition.
No, 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 we have not. It's not a question of locus. Why in a, how in a writ petition it can be?
Yes, yes. So I
That
have
is the only thing.
I have done some research on that point.
Let us see.
Should we take up another matter? The brief is coming. That because the chambers, Kiran Shankar Roy wrote.
Not today.
Item number 12.
Respondent.
Respondent. The last occasion petition of appellant did not appear. Non appears on behalf of
Item number 13.
Item number 13 and 15, we represent, I represent my lord a bunch of writ petitioners, original writ petitioners. But I represent 103.
This is a writ petition appealed by the state.
Appealed by the state.
The state has.
Who is for this? No, where is the appellant?
State has filed.
You are appearing.
If Mr. Bandyopadhyay is appearing, Mr. Shishana Bandyopadhyay. My lord, since he is evident, my lord,
Put 5 minus.
Put 5?
Put 5 minus.
there was a matter in court number 5.
On his legs, man.
Some matter, he was there, but so now I think he's engaged.
Just give us. What is it? What is it? What is the
My lord, the issue was, my lord, the regularization of the contractual employees, lordship, who were re-engaged by the food department as the data entry operators. Now, the state decided to appoint another set of contractual employees by replacing the earlier set of contractual employees. Instead of issuing the notification for the permanent vacancies, they have notified that we are going to take another set of contractual employees by replacing the earlier sets of contractual employees. So, on the basis of Lordship, 3 judgments of the Supreme Court, we argued the matter. Several questions arose, and the learned single judge considered several aspects, including the submissions of the states, and putting his reliance on the judgment. Would you kindly come to the
So
judgment?
that government decision of 2011 regarding giving some
But till 60 years.
yes.
Yes, my lord. That 2021 is there. In 2010, government has adopted the finance department. There is another notification.
16/9
It says
11 or something like that.
yes, my lord.
I don't
That
remember.
till 60 years, they will
Get
pay.
leave, they will get leave, they will get a fixed pay, and they will continue till 60 years.
Yes, my lord.
So that is the relief granted to you, or
That was one of the relief, my lord. And my lord, I want to just read the judgment once. If your lordship 307 may take a chance to read a judgment. The petitioners have.
Don't panic. Don't panic. Don't panic. Yes. Yes.
Petitioners have prayed for issuance of the writ in the nature of mandamus,
Yes.
commanding the respondents to give extension to all workers up to age of 60 years to cancel, quash and rescind the letter dated June 24, 2020, issued by the Additional Secretary to the Government of West Bengal, Food and Supplies Department, and to direct the respondent authorities to take necessary steps so that the petitioners can join in their post. The writ petitions involve common question of law and
Has
fact.
any fresh appointment been made already?
My lord, no. There was a stay.
No.
There was a stay in this.
Then what is to be done? File a paper book, we will consider.
Lordship, that
They will file paper books and we will consider. If there is no appointment made subsequently, then there is no scope for any interim order. You are continuing.
my lord, I think since they are seeking for time today, my lord.
Huh?
They are seeking time today. On the
So
count of Mr.
while
Kalkutta.
adjourning, we can direct for filing the paper books.
But Lordship may direct, but one thing, Lordship, since my learned junior friend is appearing, so he might be like, I don't know whether the state has any point, but I should be fair. So whether they may have.
No, therefore, we asked if an appointment has been made or they had proceeded, then there
My
may be.
instruction, my lord. No
If it
appointment.
has not been done, then what can be? Today, nothing can be done.
Nothing can be done today. Should kindly post it in next week anytime. Lordship, let him come. Otherwise, Lordship, this instruction.
On prayer made.
The 13 and 15 similar.
Yes, 13 and 15. You are representing the writ petitioner in both. 13 and 15.
109.
All right. It is their appeal. They want adjournment.
I will give.
Hmm?
No, no, 13 and
No, 13 and 15.
16th January. Item number 14.
My lord, I appear for the respondent, my lord. Appear for the respondent, the appellant is missing, my lord. But I was the writ petitioner which was successfully allowed. From that, the appeal has been checked. This is the impugned order once on the last two pages, internal page 8 and 9, that will clarify.
এটা একটা কেস বড় আগেরটা না একটাই বড় আমি বাবু তোদের বললাম তো রাশি ভালো হ্যাঁ কি হয়েছে পুরো বুড়ো হয়ে গেছে। কি করে যাবে এবার চোদ্দ করে তারপর জানো আপনি উঠে যাবো গ্রুপ সিক্স
I'm for the appellant, my lord. I'm sorry, my lord, I got little late. My lord, the only reasoning, my lord, that has been perhaps weighed till on a single judge, pass the judgment impugned herein, the passing of another division bench judgment, which was filed by other delinquents who are also facing the similar, my lord, disciplinary proceeding. So therefore, my lord, it has to be otherwise, my lord, should have been seen whether those delinquents were also under the same parity or not. The judgment impugned herein did not deal with that very issue itself. Whether those delinquents also, or rather there is any similarity of the actions alleged or the role played by them or the duty entrusted to them was similar to that of me, or rather that of the writ petitioner, my lord. That was never carried out. In course of the hearing, my lord, this decision was referred to before the learned single judge, and from paragraph number 20 only, my lord, the reason was given. Out of the total 9 pages decision, my lord, last 2 pages were dealing with the reasons, my lord. And the reasons solely, my lord, based upon the division bench judgment. And my lord, I would try to demonstrate, my lord, that that learned single division.
Where is the division bench judge?
Yes, my lord, it is annexed, my lord.
Where is it? Which page?
My lord, it is page number, my lord, 274. And I will show, my lord, only the single finding of the division bench was there, and that was dealing with some other charged officers. On the next page itself, my lord, and the decision starts from page number 276. And the initial part was dealing with the respective case. If my lord, may I bring your lordship to the relevant page, it's a finding. That is, my lord, page number 279. From that, my lord, the finding of the division bench on the starts. May I read, my lord, that part? There were total 18 charge officers.
The case of the petitioner in the other case, it is in respect of the same transaction, or it is a
The incident was more or less same. There was what misappropriation
so
of more or less-
2011 to 12.
Yes, madam. So, July 11 to January 12, madam. They were total.
No. From 2011 in October 2012.
There are several, 2 or 3 inspections beginning from July 11 to January 12. So
No, they are all in relation
all
to the
related to the same incident.
same depot.
Same depot, same incident. And total 18 officers were there. 2 were managers and other officers were different in the category, and therefore in respect of role as well as duty. This is my first case, my lord. Second case is kindly see the division.
In case of some eclipse they have found, then because so many person posted, how can you responsibility on him? Dismissal of remarking. But then what should be about it?
Yes.
So that is the first my line of argument. Secondly, let us see whether division bench dealt with the very issue which was also touching the issue of the petitioner, and what I can find, if kindly see on the single finding is there, so far the division bench decision is concerned. 279. Furthermore, we notice that after the entire fact finding process, the inquiry officer has made the following observation, then quote unquote, on view of the justification by the defense, direct involvement of charged officer 9, 10 and charged officer 11 in misappropriation of staff is not true. So this case, this particular division bench, the case reaching up to division bench was concerned by the 9, 10 and 11. And that finding was taken by the division bench from the IO report. And on that very basis, my lord can find the rest of the decision was pronounced. So nowhere, I am charged of the 60. I am a officer higher in category, higher in rank, and higher in the role institute. I was the weighbridge in charge. I was the person through which only all the lorry come into the depot, and through me only all the lorry would come out of the depot. So for all the entry for the purpose of the trucks and also for the purpose of going out of the depot, I was the person in charge. So and those so far 9, 10 and 11 are concerned, they was the head watchman as well as task operator. So their role was absolutely different, and moreover, I was charged with 2 articles of charges, 1 and 3, and they were charged only with article number 1. And in article number 1, the IO got certain finding in their favor, and that was reflected by the learned division bench, and accordingly the judgment was pronounced. So therefore, in my understanding, the learned single judge
He did not participate in the proceeding.
All they participate in the proceeding, but in different manner. Somebody filed, somebody
Without listening to us, you start responding. We are asking you, he did not participate in the proceeding.
disciplinary proceeding.
This person, whether he participated in the proceeding or not.
All participated in the proceeding. Disciplinary proceeding, all the charge officers participated.
We are asking you about him. We are not concerned with all. Here, how many petitioners are there?
Only one.
So we are asking you about him. Forget about all.
Yes, he participated in the proceeding. He participated in the proceeding, but he did not reply to the report of the IO officer, IO investigating officer, inquiry officer, and he also did not examine himself. And so far the benefits.
He submitted a WS. He submitted a statement of defense.
He submitted his defense, but he did not reply to the memorandum of charges, and thereafter he did not file any reply to the report of inquiry officer. But
Then what is then how is participated? That's what we are asking you.
But he participated with defense assistant. There are total 2 defense assistants, and one defense assistant was representing 4 charge officer, and another defense assistant was representing remaining
Sir, counsel, there is a charge memo is issued.
Yes.
Then the delinquent is required to give his statement of defense.
Yes.
Then if he pleads not guilty, he claims that a proceeding be conducted, then proceeding is conducted, then he participates. So did he file a reply to the charge memo?
Not to the charges, but so far the defense brief is concerned, he submitted his defense after the hearing was concluded, and he was represented by the
after the hearing was concluded.
Yes, and he was represented by a defense assistant, and he did not examine himself. Those are the points in my.
No, he did not participate.
But through his defense assistant.
What defense is somebody is standing there? That means participation.
In that way only they are all, most of, well, all the, I should say, Malar, all the charge officers were represented in that manner only. Nobody has questioned Malar. So far the participation is concerned, Malar, nobody has questioned. They participated, thereafter they dispute, they challenge the order passed by the disciplinary authority to the appellate authority. They did not take this point because they participated in that way.
The appellate
It is not their case. It is not their case. They did not participate or they did not. He was.
Why they will say they have not participated? How they will benefit from saying this? How they will benefit?
Given all the opportunity, Malar.
Sir, they have not said why. How they will benefit from saying that we did not participate?
So that they can say they are not given any opportunity to participate.
Not given opportunity and not participating are two different things. We are asking you if they have not participated. We are not asking you whether opportunity was given. You have given opportunity, you have served charge memo, still they have not participated. So where is the question of no opportunity?
There is an option to participation through defense assistance also. So in that.
Sir, unless somebody responds to a charge memo, what the defense assistant will do? I will appoint a lawyer, I will not file any opposition. What he will do?
So far my knowledge goes, my lord, he did not reply to the, my lord, the charges.
To correct my learned friend, my lord, we have replied.
Yes, wait. Did he file any reply to the charge memo? Did he file any defense statement?
Defense statement he filed, but inquiry report, reply to the inquiry report he did not file.
And reply to charge memo?
Reply to the charge memo, my lord. So far the order, my lord, inquiry officer is saying, my lord, let us see, my lord. He has said he did not file that. From that basis only I am saying. My lord, inquiry report is at page number.
That is your case recorded by the learned single judge. You have said so before the single judge that he has not participated in the proceeding. It has been recorded in the order. At least twice or thrice. And you don't know.
My lord, let us see, my lord, inquiry report, my lord, once.
You must have filed an opposition. See your opposition. What inquiry report will do? See what you have said in the opposition.
Opposition is perhaps is not made part of this, my lord, the writ petition.
Very good.
But my case.
That is your stand and you have not annexed it. Wonderful filing you have done. And we should go through the inquiry report as if we are sitting in appeal over the inquiry officer's report.
Oh, sorry, I'm sorry, my lord. I'm sorry. I'm sorry. Extremely sorry, my lord. 237, my lord.
You have not stated anything whether he has.
So far that the same thing has been stated here, against the inquiry report, they did not file.
That
any-
is all you have said, yes.
So, so far, I beg to be excused, I am taking instruction whether they have filed any reply to the memo of charges or not. But so
No,
far the
because we
finding-
found at 3 places in the judgment, it has been recorded.
But Mala, the finding is only on the basis of division bench judgment. Perhaps that did not, that was not the instrumental. Mala.
So how many officials were proceeded against in total? 80.
18.
18. So you have dismissed all 18.
No, my lord, not dismissed, or not all dismissed, my lord. 3 were, my lord, lesser penalty, were in charge of quality control, and others were, my lord, other 15 were. So among them, my lord, 7 did not challenge the. The
So
decision.
all 15 persons are responsible for the pilferage.
For different categories, my lord, different persons were interested in different jobs. Somebody in charge of said.
Their charge is of pilferage.
Pilferage, several charges were there. One was, my lord, the misappropriation. Another was there, my lord, for not taking the proper stock of the, my lord, the accounts of the food grains. Another was, my lord, not keeping proper accounts of the weighbridge functioning. And fourth was, my lord, regarding the quality control of the whole stock, because they were also taking measures for quality control.
Where is the charge memo?
Yes, my lord. Charge memo is, my lord, starts from 61. I am told, my lord. I'm told, my lord, they find a simple denial without dealing with the specific allegation. The relevant part starts from 63, page number 2.
So there is a common charge memo for everyone.
Yes, ma'am. So what charges is there, my lord? There are no specific, but the role played by them has been, yes, charge memo is common for everyone.
Then what else parity is to be shown?
From the inquiry report, my lord. Inquiry report, my lord.
Nothing.
They,
You have no
specific
case.
that is referred to, my lord. The role, in course of hearing, my lord.
You have no case, sir. Sorry.
In course of hearing, my lord.
You have not proceeded with seriousness. It is obvious.
My lord, total 18 official and kindly
Yes.
see the.
So there is no distinction. You say all of them are responsible for everything.
Yes, my lord.
It's a collective charge. There is no individual liability cast on anyone.
In course of
And one is being dismissed. Wonderful.
but in course of, let us see, my lord, what.
No, we are not going to. We are not going to. This is not an appellate forum. We are not going to see the inquiry report.
That is so, my lord, they kindly see whether division bench, decision applies to me or not, my lord.
That we are seeing. How it cannot apply the same charge memo.
But my lord, the finding is in respect of only 9.
You may give whatever finding you want.
But 9, 10, 11 is.
Come to the list of evidence and witness annexed with the charge memo. So witness and evidence is also same. Charge is also same. Everything is same. And you want to give a different punishment.
But because role played by them different.
Enough.
And that my lord transpired in course of hearing.
No, we have understood. You are saying that parity has not been shown, but parity in punishment has been given. This is the substance of your case.
But it is not so, my lord. Kindly see one. Let us see, my lord, what is there in the disciplinary order. Respective roles were has been my lord properly deciphered. And
how can it be? There is no separate allegation.
Article 1, 2, 3, 4 has been, my lord, applied, though separate officers were not mentioned
Then-
in respect of
then-
each and every allegation.
Then it is impossible.
But the roles were, my lord, meant to be played by different officials.
It is all in your mind. It can be in your mind.
Certainly, my lord.
In paper, there is nothing.
Well, kindly see the charge memo, the officers and the rank my lord, they are holding at that point of time.
Not
And the place of posting and the.
that we will consider, that we are considering, that they were all holding different posts.
Yeah, different posts, my lord. Kindly see the finding of the division bench.
Yes.
Finding, my lord, against the 9, 10 and 11, and they were charged only with Article 1. And this petition was charged also with Article 3. That was my lord waiving. And they were task operator and head watchman, my lord. Certainly, my lord.
9, 10 and 11 were charged with only with Article 1.
Yes, my lord.
Show from the charge memo that it says anywhere that 9, 10 and 11 are
In
charged.
courts of, my lord, in courts of it was found, my lord, the charges.
What is this? If they were not charged,
Yes.
you say this, you say only these charges were proved. They were proceeded against for all the charges.
I cannot improve the memo of charges,
Then-
but certainly, my lord, in course of hearing the different.
In the course of charge, they were not charged. Don't use the word charged. They were all charged for all allegations.
Yes.
But only 3 charges were proved for him.
Yes, certainly. my lord.
It's not that they were charged with a different charge.
But my lord, the charge, the official
Enough.
charges are not applicable to everybody. For
That's
example,
enough.
the person who is in charge of every, that charge, my lord, it is apparent that those charge does not apply to charge officer 1 to 9, for
We
example.
have no case. Yes.
For example, charge officer 1 to 9, my lord, those are not.
We will consider that. Heard learned advocate.